Dear colleagues, ladies and gentlemen, I would like to start our roundtable discussions by giving the floor to the Deputy Minister of Justice of the Russian Federation, Elena Borisenko, the person who is very talented and is paying a lot of attention to this forum. Well, don't be shy, someone had to say that. Elena Borisenko has always paid a lot of attention to our topic, and this is the first time she came here to open our roundtable discussions. Thank you very much, Svetlana. Dear members of the panel, delegates, ladies and gentlemen. It is a great pleasure for me to come here to open this session. It is the first session of the day. I understand that experts cannot start as everyone else at 10. They have to start earlier, half an hour earlier. They have to make sure that everyone who comes at 10 got worried that they have already missed everything. And I would like to say that this is again a great pleasure for me to once again confirm that I'm in love with the forensic science. I believe it is a great science. It's a wonderful science because it brings together all the technologies, but at the same time it requires the highest degree of skills and knowledge of law. It's a unique combination. Every expert who is involved in this sphere is of great value, because these kinds of experts usually combine the knowledge of humanitarian subjects, but at the same time brilliant technical skills. This combination is important to make the law prevalent, to make sure that the evidence was as objective as possible in order to be able to determine the truth and to assist in a fair trial. In different countries and all over the world, we see a lot of new trends in forensic science. Technology changes very quickly. It advances fast, and there are a lot of new things that are happening in the sphere, both positive and negative. I think it is quite a challenge to forensic experts because we have to make changes, get adapted to the new problems, develop new methodologies, introduce techniques, and at the same time not to lose the quality. I think many of you present here know that in Russia we have developed a draft law on expert and forensic examination. This bill has gone through the first reading, and hopefully this year our Parliament members will adopt this law, and that means that some clarity will be introduced into the work of forensic experts. We live hoping for fast changes, for changes to come soon, and since I'm responsible within the Ministry for Forensic Science of Russian institutions, I have to say that the legal framework is a little bit behind. In fact, a lot of things, a lot of provisions that we have designed into the bill are applied by experts every day, which confirms that the core of experts that work for the Ministry of Justice and many different government institutions are very skilled, qualified, and it also proves that we have a great potential in Russia. And with this regard, I would like to thank Jan de Kinder. He came here for the second time, and also Lilian Trissy, who came here to help us to exchange opinions and views. We have a lot of esteemed colleagues from Armenia, Azerbaijan, Kazakhstan, Kyrgyzstan, Mongolia, and other countries that we are actively involved in cooperation will continue to be our partners. Science does not tolerate borders. Science goes beyond the national boundaries. The experts live in the same space of technology, and there are no limits. Forensic examination is supposed to ensure the quality and fairness of justice. Both parties in court file for forensic inquiry when legal interpretations are not sufficient. In this respect, additional examination should be objective, but since experts are people, they are humans, there's an element of subjectivity, and I believe it is important that we strive for more objectivity and develop this field further. I wish you for fruitful discussion. I'm sure that our discussions will not be limited to this roundtable discussion. I'm sure that our discussions will bear fruit, and the results of our discussions would be beneficial for all the experts, for the entire forensic community, and I'm sure there are a lot of issues that require our attention and discussion. Thank you very much, and we'll see you later. Thank you very much, Elena. Let's continue our discussions, our roundtable. Well, as our experience shows, such meetings of forensic experts, meetings that involve experts of other fields, are extremely useful. And now we will continue our tradition, and we brought together a lot of old friends, colleagues, partners. I'm sure that our panelists today will share their ideas and innovations. They will discuss the current trends in the expert community. They will cover those issues that require our specific attention today. One of the most relevant issues, which I believe will remain high on the agenda of the expert community, is this. So, what prevails, subjective or objective in the forensic examination? The challenges of time determined the need to move up a level in the forensic technology. Today, both the law and the law enforcement agencies require additional level of expertise from our forensic science. The price for a mistake is becoming even greater. There are a lot of non-government institutions that provide expertise. Among them, we know there are colleagues who are well-educated, people who have the best technologies, but at the same time, there are experts who are looking for profits only, and they leave behind the responsibility each expert is to bear when writing an examination conclusions. Just like Yelena mentioned earlier, and I totally agree with her, we may have wonderful technologies, we may have excellent techniques, great educational background, but if it's all about people, and if people are not acting in good faith, if the psychological foundation of what is going on is not proper, then one cannot expect this kind of examination to be objective. The examinations that are currently ongoing in the forensic science revealed that there is a direct link between mistakes made because of the lack of knowledge, too much imagination, and the mistakes in justice. Scientists have come up with an idea to develop an overall concept to cover the psychological element of human expertise. Here, during this roundtable discussion, we will try to discuss not only things that we all know about very well. We're not only going to discuss things that you care in terms of objectivity and subjectivity of expertise, but we will also want to learn new things. We would appreciate your critical views. We would appreciate as well your positive recommendations, and we will definitely take those into account in the bill which is being worked on as we speak. I would like to give the floor now to the professor in the Higher School of Economics, Mr. Nesterov. Anatoly Nesterov will discuss the methodology of objectivization of forensic examination as a factor increasing the evidence base for the court. The problem of the objective and the subjective, as well as the line between them, became the subject of the justice science of justice and the criminal process a long time ago. It was also studied in the forensic science and is covered in a number of publications. The transformation of the title in the research area, such as which was formerly called forensic examination, into court and forensic activity, determines the need to study this problem further. I have to note that the leadership of forensic structures and the practitioners are very much ahead of the judicial science and have studied these problems for a long time. We have to state here that the problem requires additional focus, and it requires specific recommendations that could be issued for the administrators of the Ministry of Justice and the legislature. Today we have a lot of private forensic structures, both commercial and non-commercial. They act under the law on the government forensic activity in the Russian Federation, and today publications demonstrate a whole range of very different points of view on the terminology of in forensic science. The methodology, the technique requires from researchers to follow the terminology, and it is important that the practitioners did not use too many metaphors. Unfortunately, people who have not been involved in this area for a long time often create their own terms, and these terms are spread by the mass media. In order to improve the evidence value of the forensic examination, it is important to look for objectivity of all the components. The most important element here is the evidence value, because objectivity here is only one of the constituents. So first we'll talk about the evidence value, and then we'll move on to the elements of objectivity. The history of forensic science showed that first it appeared as an activity, as something that was that the lawyers were involved in, and then it became a subject of research. The lawyers of the 50s of the past century proved that an expert cannot be a judge, even based on the scientific discoveries. In the 60s, sociological methodology was applied, and often sociologists call the findings examination results. In the 80s, expert systems were created to replace scientists, but that was a failure. And now we work based on the idea, which came from medical science, the idea that we can work from facts, get away from the quality assessment approaches, but I would like to prove that we have come back to where we started, because analytical work is the examination that originally emerged in jurisprudence. In our view, we have to make sure that the so-called court and forensic activity includes both the expert activity and the activity of the expert. Even though some of the authors in this area mix those two terms up. The existing international and national experience proves that the methodological support to research in this sphere should comply with international and national standards, as well as the standards of organizations to comply with the federal law on the technical regulation. This is Federal Law 184. This means that all the techniques and other procedures used under in such examinations should comply with the federal law of the Russian Federation, number 73. However, apart from the standardization of techniques which need to be certified, there should be a certification system for the structures that actually perform the examination. It is important that these structures should also possess special procedures for the validation of their research methodologies. An organization cannot work well if there is no professional growth of experts, if there is no system for certification of experts, because anyone who works in an expert structure needs to go through a certification procedure within a specific expert area. Such certification means that the competences are checked and that this particular expert has all the necessary skills and knowledge. Later, this certificate is issued to confirm the competences of a specific person in an expert specialization. The leader of an expert structure, which is involved in examinations in accordance with Federal Law 73, is responsible for the quality of examinations, and that means that he's also in charge of the standardization system, certification, and training and retraining of the personnel. One of the modern trends that we currently observe in international forensic examination organizations is that there is a quality management system, and the Russian Federal Center for Forensic Examination pays a lot of attention to this specific area. For example, an international seminar was organized in April 2014. This seminar discussed a number of relevant issues in forensic science. The notion of quality is subjective, and therefore it is important to understand whether this quality can fit the requirements of international quality standards. And all these systems that I mentioned earlier can guarantee that the objectivity of expert product will meet the requirements. They will be able to be reproduced, and this would mean that the results of the findings of experts in court would be quite objective. The structure that has all the elements that I mentioned earlier in place will be more objective. Unfortunately, there are a lot of expert structures that call themselves independent. In fact, in the beginning of the 90s, we saw a whole new trend when a lot of things became independent, and therefore the legislation of the Russian Federation now has a independent examination as a term. But the private expert organizations that call themselves independent should make sure that their staff or their experts are objective, because this objectivity should be checked, not just declared. The competition between government-run and private expert organizations for the right to perform expert examination should not be in the field of independence, because the independence of government experts is guaranteed by the relevant articles of the Russian legislation, but in the level of objectivity of the expert findings. In this respect, in order to make sure that there is a competitive environment in this field, we need to create an accreditation system that would be implemented by the federal authorities as well as by the non-government expert organizations. We have a number of examples of such systems. Obviously, government structures usually use their own expert structures, but sometimes they have to apply to private expert organizations. The fact that the private expert organizations are here is an objective fact, and the government expert organizations sometimes cannot perform the entire spectrum of examinations. Sometimes they are not capable of providing for the scope of examinations. But apart from the government customers, there are other subjects that might be interested in conducting such examinations, and therefore there is a whole market of the so-called expert services for businesses, for private individuals, and for NGOs. The private expert organizations, however, should not be seen as something that stands apart from the government structures. I think there should be a complementing mechanism. It is important to discuss and explain that these organizations, even though they may be called independent, are not independent. They do not have the monopoly for the objectivity. In fact, recently we have seen the emergence of a service for checking and examining the objectivity of expert findings. I'd like to mention that there is a new trend in calling the assessment or examination of a court expert with a new term, a review. But this is a wrong practice, because that is not what a review means. We cannot agree with the fact that the procedure for reviewing consists of a detailed analysis of materials, methodologies, etc. There's also a notion of examination and assessment. When we say assessment, it means that this is a legal assessment of an expert examination project. This assessment can be made by specific people, and based on that assessment, a decision may be made in order to repeat or carry out an additional examination. We know that there is a presumption of truth for every findings of an expert, because every conclusion, every a document signed by an expert is considered to be true until it is not proved to be wrong. But since this is still considered to be evidence, this expert evidence should be seen as just one of the pieces of evidence, and it is not compulsory for the court or other people who make legally bound decisions. So they are the ones who determine the objectivity of this expert evidence. However, those parties that may be interested in it may initiate the check and recheck and the assessment of the expert findings. In conclusion, I would like to say that the entire logic for the development of forensic science and the practice by professionals require the determination of objectivity, and the objectivity should be seen as a factor that increases the evidence value of the examination results. And that means that the researchers in this area should pay more attention to the characteristics of expert relations between different organizations. Thank you.
So we could all just stand up and go away, because all the challenges and problems were covered by Anatoly in his presentation. However, in practice, things are much more challenging and complicated. So if the forensic investigations and assessment of the substances and patterns is very sophisticated matter, so if you can rely upon your own personal potential and qualities, and also theoretical and practical capabilities for a forensic expert, from the viewpoint of the investigation process and the knowledge that the forensic science can provide, everything sounds very exact. However, there are areas in forensic science, like psychology or linguistics or handwriting assessment, where the expert needs to rely upon his own human potential, his own expertise, because he thinks that other people wouldn't understand it as well as I can, and I can basically give an expert opinion, and I can intervene into some criminalistic things in due right, and no one will stop me. Validation, competence, taking competence tests, just to check the professionalism of the expert, provides for the opportunity of turning from subjectivity to objectivity. And I would like to invite questions from the floor. We have to have a good discussion here. So it's a good old friend from the first session. Oh, I do love your session, really. And so far, just for 15 years, I've been practicing to understand the major principles behind forensic science. I failed to understand the basic principles underlying forensic science, so I'm always a sympathetic listener of all your discussions. Among the experts themselves, there is no uniform understanding of the structure of forensic assessment and investigation so far. However, I have some questions to the presenter. It's a question, and on the other hand, I would maybe you could provide your own personal opinion about subjectivity versus objectivity in forensic science. So the procedure of the forensic assessment begins not from the activity itself, but from the problem posing. Is objectivity or subjectivity affected by the questions or tasks set before the forensic scientist, and do they affect his choice of the forensic method or technique to provide a solution to the problem or task provided by a person? And to what extent subjectivity or objectivity of involving and problem statement for the forensic scientist are affected by that? Yes, so what is an object per se? So it's an objective quality which subject subjectively chose. So all the objective contains some subjective dimension and vice versa. And some subjectively posed questions and tasks set do affect the objectivity level of the opinion. And but we involve forensic experts for this very matter, to ask them the right questions. On the other hand, there are legal rules and regulations so that the stakeholders might be involved in that. So if the parties involved in a certain competition just participate in problem statement or task setting, and just they involve competent people who have special expertise, then we reduce the degree of subjectivity. Just as to attorneys or defense, and we need to get involved in that process more actively if it's an arbitration setting. And I would recommend to, if you just are in dispute with the state bodies and authorities, so I would strongly recommend to involve competent persons to represent a party. They might ask you very uneasy questions because they understand the essence of the question. They just can do it without appointing an assessment. Are you satisfied with the answer? May I also add a couple of words? State-run expert centers carry out a lot of methodological work that has a legal enforcement affair. So we do trainings with the investigation corps, in the attorney corps, and the court corps in different regions of our big country. This process is organized differently. However, if it's in place and duly organized, the questions are fully in line with the investigation to be carried out. However, where the situation is different, the problem and the task setting process is not effective, and this is beyond our competence, because we are not in a position of being responsible for legal dimension of the investigation. We have a limited scope of our competence, which relies upon our special expertise. So if we do it right, we don't entail any problems. In Moscow, in St. Petersburg, judges on the very last day of the month would invite experts from various disciplines and fields in order to inform them about the new methods, techniques that have been developed. So what kind of new questions appear to which a forensic scientist can offer his own answer, because we invite experts from research institutions, from research and practical-oriented institutions, and others. So, in order that the audience understands your question, my question, forensic science or just specialist experts, this is not taught in the universities. So that the judges will appoint the assessment for 3 to 5 times because it takes time to formulate a question in the right way, to pose the problem correctly. Any other questions from the floor? Please identify yourself, introduce yourself. Schlabovic, Tatarovich and partners. Tatarovich from Voronezh. In my practice, I often face forensic assessment, and we have a lot of expert organizations that mushrooms. I think the major problem of them are the methods and techniques they are using, because it is difficult to control the development of science. So in my practice, I often face a situation when an expert said, I wrote an article, and basing on the article, I invented a new method. To what extent this method can prove objective and scientific, no one knows. So the expert opinion is a Pandora box, because there are input data and output data. So the court judge takes the output data to rely upon when ruling, when just having a ruling. So we need to approve formally the methods that can be used for forensic science. Of course, an expert can freely choose from the whole arsenal of methods. However, we need to be confirmed that all these methods are scientifically proved and objective. It's not just, it shouldn't be just an idea that leaves a lot of room for frauds and falsifications. Thank you very much. You asked a question that today in the new legislation on forensic science is reflected. So as to state-run forensic institutions, we don't have problem in this area because all of these methods are determined and approved of by the Russian Federal Forensic Center, because a person might stand up and says this method is not on the list of the approved and validated list. As to the private forensic scientists and experts, so this is the second reading of this legislation. And why so? Because it took a whole year for the private experts just to lobby their interests in the high bodies of power. They don't want to get proper training in state-run institutions, nor do they want to validate the methods that they're using. What they want, really, is to bring methods and techniques to the court so unique that if one wished to repeat it, that would deem impossible, because they think that this substance can be dissolved in this just dissolver, so they just say that the state-run methods are not needed, and we will tell whether this document was signed today or yesterday. I always tell experts that you prove the validity of our method by bringing reagents to the court, because the court judge does not understand physical or chemical processes. They can have general knowledge about things. So illustrate this, bring the reagents to the court, ask the attorneys where they found this or that method. So should this legislation be approved and adopted this year, so then the whole community of non-state-run, non-governmental experts will have to follow a new set of rules where all methods have to go through accreditation and validation, and all private experts and scientists, I'm not saying that all of them are incompetent. There are very good people who just used to work for state-run institutions with proper expertise and competence. They will have to take the competence test, and they will be put on the list of the official forensic experts, so the courts will not be able to appoint their puppet experts. We are very much looking forward to this legislation. We should have had it in July last year, but you're right in saying that this is a very challenging and sophisticated thing. There is a huge army of experts. We are about 20, just 500 of state-run experts, and there are thousands and thousands of private ones in the regions of Russia who make money from the air. So they name themselves very close to the state-run institutions. So this is a real challenge, but I'm sure we'll win, because that was the task given by the country's leadership, just the in terms of enforcement from the very high-standing level. So we're working to achieve the task. Thank you very much, Svetlana. My name is Dmitry Makarov. I'm just a practical attorney, so just the competency training we are doing with our young attorneys, just appointment and including appointing, discussing forensic assessment in the court proceedings. However, I would like I wouldn't like to speak about that, but rather about the possibility to regulate the activity of non-state experts at the state level. Honestly speaking, I'm against this approach for two reasons. I think this regulation will suspend and stop the forensic activity, because, as we know, the time taken by accreditation process is really quite long, and new methods, no new methods will appear, or if they do, it will take a lot of time and they will come up kicking and screaming. With all due respect, with the state-run expert activity, we will also slow down the process. You know how much time the evaluation takes if it's appointed to be carried out by a state-run forensic institute. So no court procedures, time limits and deadlines can be met. A great number of so-called puppet experts, as they were called, is intimidating indeed. On the other hand, if we look at it as a probative kind of evidence, and if we speak about not the formal side of it, but about the competitive side of it. So if the other party does not agree with the method, they can voice their objections in the court. So just I think it's better to see many experts, wide-ranging and different opinions. We don't object against their number. We just want to ensure their professionality. You cannot carry out the economic assessment per 1 week, because there are many boxes and containers of documents that one has to review. So in state-run institutions, we do such evaluation from 3 months to a year, and in the private institutions, they do it within a week. But if they receive the opinion of such a private 1 week expert, tell me honestly, how many times there was no need to reappoint another assessment after that? Because the arbitration courts, court judges, they appeal to the country leadership with a request to help them get rid of the private experts and put them in contact with the highly qualified professional state experts, so that they could work more efficiently. Thank you very much for your discussion. We have a second presentation looking at the competence, the thing without which the just expert community has no right to carry out its activity. So competence validation is important. In the Soviet Union, we always focus on the quality of the opinion, and he had to have the right of signature, and before that was achieved, and he wouldn't be able to carry out his activities. So it's also an issue of great attention among the European criminalists, and it is very important to hear that about from the just the chairman of the general director of the just national Institute of Criminology and Criminalistics, Jan de Kinder.
Dear participants, first of all, I'd like to thank you first, the organizers of the meeting, to provide me here with the opportunity to speak at the International Legal Forum, and in particular Mrs. Smirnova, who is the director of the Russian Federal Center of Forensic Science of the Ministry of Justice of the Russian Federation. This meeting here provides us with a unique opportunity where scientific practitioners and legal parties meet. And I will, during my presentation, try not to be too technical, and I hope that this will allow the full audience to follow my line of thought. I will be addressing today the importance of a reported and proven technical competence of the forensic expert in the laboratory in order to assure the objectivity in the expert opinion delivery. And in particular, I'm going to focus on what actions we undertook to establish this in the Belgian forensic laboratory. I have prepared some slides, but I don't see them on the screen. I think perhaps somebody can put the slides on the screen. Yes, thank you very much. First of all, what are the human-based methods in forensic science? One that certainly everybody knows concerns the comparison of fingerprints. The actual comparison of fingerprints is done by a forensic scientist who has acquired a lot of skills in identifying fingerprint minutiae, which are the particularities in each fingerprint. There exist a number of automated systems for handling and comparing databases of fingerprints, but it remains up to the forensic scientist to make a decision on the origin of the fingerprint. And the forensic expert will base his decision on the initial training he received at the beginning of his career, as well as upon the experience he has acquired so far. Hence, the decision he takes will be subjective. Another forensic scientist may come to another conclusion. And how can we guarantee that the same conclusion will be taken by different forensic experts? In other terms, how do we guarantee the objectivity in this field? A second example of the human-based methods constitute a comparison of microscopic marks left by a firearm on a cartridge case or a bullet. These marks are in general unique and will allow a forensic expert to identify the firearm which has fired a particular cartridge case or bullet. And similar to the previous example, the objectivity of this technique can be questioned, and we have to provide support in order to arrive at objective results. A third example is the comparison of the analysis of blood pattern, which can sometimes be found after a crime was committed. The patterns are of extreme importance as they provide a recording of the dynamics of a crime. One can deduce how a fatal blow was given to a person, what the orientation and the position was of the body of the victim. It's also of extreme importance in order to distinguish the blood pattern from the victim and potential also these from the criminal. This field is also based on the human brain, who examines a particular pattern found on a crime scene. These are three examples of human-based methods where the human brain will examine patterns according to the traces left on the crime scene. Other ones include fingerprints, firearms examinations, blood patterns, ear prints, shoe prints, and tool marks. Also, handwriting, facial recognition, and hair analysis corresponds to this group. So we have, on the one hand, human-based methods. On the other hand, we have instrumental-based methods, where example is examined with a scientific instrument. For instance, the determination of the alcohol content in blood is a good example of these techniques. The objective of forensic methods is to obtain results with a measurable quality relevant for the criminal justice system. And those results need to be consistent, reliable, and accurate, which means that during the whole process of the introduction or implementation of a new forensic method, a specific step must be taken in order to prove in an objective way that the method is suitable for its intended use. And this process we call validation. We already talked about validation before my presentation. For the instrumental-based methods, the validation of these techniques follows a number of criteria and tests which are well defined in scientific literature. However, how do we deal with human-based methods? Well, there are three elements of extreme importance in guaranteeing the quality. First of all, there's the competence of the people working in the forensic laboratory. Not only the forensic experts are involved, but all the laboratory people, laboratory assistants, even evidence reception desk. We will be examining this further in my presentation. And the second element is the scientific methodology. Does the forensic expert follows the method which will provide good results? Does it have scientific flows? Are there better methods available? And if so, why are they not used? And third element here is the sound scientific methods needs to be correctly applied in the laboratory as well as in the casework. The competency of a forensic practitioner, an important element, as we discussed that before, relies on 4 factors. First, there's a theoretical knowledge of the field of forensics. The person needs to be a real expert in the field and be aware of important scientific results which were obtained during the last years. Secondly, the people who are working in the laboratory need to have the right practical skills to execute the analysis. Thirdly, a professional attitude is essential. I think that another speaker will talk about this issue later during this session. And fourth, a controlled experience in the laboratory is very important. There has to be feedback from the cases in which the forensic expert acquired experience in the past. This applies to new people in the laboratory as well as to the experienced forensic scientists. In order to check the elements of the competency, 4 areas of attention can be defined. These include theoretical examination of the general forensic knowledge and knowledge in depth within the forensic field in which one is working, a supervision of the verification of the practical work performed in the laboratory. This can be achieved at audits, but also in daily business by having another expert who is redoing somebody else's case. This way of working and how results can be drawn will be items for discussion between them. Practical performance tests can be organized by mocking casework, and the monitoring of the experience is a necessity. It will not be sufficient to prove at one stage that sufficient knowledge and experience has been acquired. This will have to be followed during the whole career of a forensic scientist. So how did we achieve this in the Belgian Forensic Laboratory? Well, first of all, an evaluation has to be performed at the end of the training of a forensic expert. Are the objectives set forward for this method achieved? If so, the training will be ended and the method will be added to the competency matrix for that unit. If not, the person will have to redo his training. Secondly, a need for retraining can be determined on the basis of one of the following three observations. First, a forensic scientist makes a number of errors at a particular type of analysis in a laboratory. Second, the forensic scientist fails to perform a proficiency test correctly. What's a proficiency test? Well, it's a number of tests made available in order to check that your laboratory is performing correctly on mostly an international level. Third, if a particular method has not been performed during a particular time, a number of months, due to absence in the laboratory. An absence can be sick leave, maternity leave, for instance, or, for instance, other tasks given to that person due to a higher priority. And every 6 months, these elements will be evaluated for all the laboratory personnel. If the need for a renewed training occurs, the unit chief will propose certain training activities. So every collaborator will have to take care of his own personal development file. This file contains information regarding training and educations which have been attended by that person, internal, external seminars which have been followed, as well as international conferences attended. My laboratory invests heavily in training and in the participation of my staff in the different scientific meetings which occur mostly on a European level. All the reports will have to be reread by second experts, and in the case of human-based methods, their finding will be compared. And if both opinions deviate, a third expert will have to perform the casework again, and his voice will be determinative in a discussion. This stimulates heavily the discussion within the laboratory, which is also very good to acquire more experience in the field in when somebody is working. And last but not least, we will provide an online access to our digital library of journals so that all experts can keep their knowledge up to date. So we have examined a number of additional possibilities for which we have not yet opted for. We have used them already in one problematic case we had, but they could be elaborated further in the future. And that's, for instance, an audit, scientific audit of the laboratory can evaluate the current way of working and propose improvements for the scientific techniques used so far. It is possible to ask for a second opinion on a whole case, not just a rereading of the expert opinion, in another international laboratory. And third possibility, which is, I think, also available, it's also possible to send in a mock case and imitate a case which was prepared from the police authorities to see what are the results obtained so far. And I know that, for instance, in the Netherlands, this is a technique which they use to check the performance of the laboratory. So I think this gives an overview of how we implemented this in the Belgian forensic laboratory. For those who are further interested in this subject, there's a document available which is called Guidelines for the Single Laboratory Validation of Instrumental and Human-Based Methods in Forensic Science, which was established by the European Network of Forensic Science. If you're interested in it, I have a couple of copies here with me. If the copies are not available, please pass me your business card and I will take care that you will receive a copy of this document. I would like to thank you all for your attention, and I'm open for discussion.
Thank you very much. It would be great if we had at this session our colleagues from the non-state expert organizations and you would invite them to the European Communion of Forensic Scientists for them to undergo accreditation, and then they would be able to work in the market. No questions? We still have time. This is it. No questions? Okay. Yes, well, you're welcome. Good afternoon. Vitaly Ivanov, the independent expert. And I have a question to our Belgian guest. In Belgium, what is the driver for the expert community in increasing the knowledge of experts? Because in Russia, we are trying to do that through administrative measures. But how does this happen in Belgium? So to improve one's knowledge, what is the driver for the expert and for the expert community?
The driving force or the judges or the prosecutor who feels that the quality of the expert opinion should be excellent. So they are driving, in fact, the demands for having a better quality of the expert opinion which are delivered. This has resulted in a number of legislative issues. One of them is the obligatory accreditation in a number of fields. The second element, which is currently under the way, is setting up of list of recognized experts, which will be including state experts and which will also be including independent experts. This is a process which is currently on the way. And my personal belief is that it should somewhere be complementary, because within the state organizations we have quality standards, international quality standards which are available. For the independent ones, independent expert, there are systems of accreditation available which can be provided by organizations, I don't know whether they exist in Russia, which group together the independent experts, so that these organizations will also reassure that the quality of the independent expert is reassured.
Thank you very much. Thank you very much. Thank you.
Thank you, Anatoly, and thank you all the previous speakers. And now let's move on to the next speaker. It's going to be on the standardization of methods to be used in forensic examination. And this is the topic that was in fact touched upon by Jan de Kinder, but we will give the floor now to the head of to Ms. Zamarayeva, who is the head of the Expert Examination Center in the northwest of Russia. Well, as some of the speakers today mentioned, we can see that the requirements to quality has increased. It is important to train properly the experts, and it is important to unify the approaches and methodologies. Therefore, it is of great importance to standardize the activities of experts. This standardization should make sure that the overall quality of justice is improved. We can see that there are some good practices both in our country and abroad that need to be implemented. The examinations, forensic examinations, should be done in accordance with the Russian national strategy for standardization, and the standardization process should involve both the training and the methodology. The federal law on forensic examination is now being considered and reviewed by the deputies of the State Duma, and It will be taken into account in developing the certification process. This certification will ensure the single approach to examination both in government-run and independent examination, forensic examination institutions. In order to make the examination objective, it is important to standardize typical examination practices. With the advance of science and new technologies, this task is becoming even more daunting. The new technologies make, however, possible to classify specific characteristics and objectivize the examination results. We have a number of areas where, however, such standardization is possible, such as, for example, graphic and signature examination. Therefore, this is one of the areas where formalization and objectivization is possible. Right now we can see that there is a prevalence in the methodology that even though the true objectivity is not possible, but if we increase the number of elements that in the end form the overall result and they become more objective, then the overall degree of objectivity is increased. There should be a number of standardized procedures put in place that experts employ in order to examine various subjects. Such standardized methods and approaches should be used by all examination centers. It is also important to mention that there are a number of negative trends that are mostly related not to methodological but to organizational issues. For example, the lack of overall concept of standardization of various types of forensic examinations. Therefore, a private theory of standardization of forensic examination could be helpful. It could change the work to make it more progressive and active. In order to harmonize forensic examination activity and the standardization activity, raw standard created a technical committee which was entitled Forensic Expertise and Forensic Examination. This committee was established on the 13th of May 2015. This committee is similar to the technical committee ISO 272 in the International Organization on Standardization. The technical committee will pursue the following goals: to promote unification in forensic examination, including terminology and definitions, systemization of national standards and the rules of standardization, recommendations, ensuring the unity of measurements, technical and information compatibility, the establishment of a system for the quality assurance of search and transfer systems, promotion of the unified requirements on accreditation and certification. In order to harmonize Russian practices with the world practices, it is important to adopt the new revision of a national standard, GOST P 52960. There is also a plan to adopt a number of national standards on terminology and definitions. That would include such areas of forensic expertise as audio and video examination, signature examination, examination of documents, computer examinations, etc. So we can see that the overall the practical findings of Russian researchers and practitioners need to be put together, examined and analyzed, and then that would create a database that could help the standardization of practices. Thank you very much for your attention. Colleagues, the creation of a technical committee, the establishment of a technical committee, is one of the achievements that we discussed in the previous meeting. This was the issue that was raised during our discussion, and to our surprise then, I think we were very lucky. Among the speakers, we had the deputy head of the accreditation body, the main accreditation body of Russia. When he heard this presentation by Jan de Kinder, when he saw that the Russian experts need to be accredited in Europe, he said, that's not right. We have been involved in this, why don't we do it ourselves? Because you can get accredited in many different areas, but you cannot get accredited you could not get accredited in forensic examination. We've never had a committee of that kind, and now after the last forum, after this session, within this year, this technical committee was created. The committee comprises forensic institutions that belong to all agencies, leading experts in the field, judges and lawyers, non-government organizations and non-governmental experts. All of them are in this committee, and Yelena Borisenko, Deputy Minister of Justice, is the head of this committee, and I'm the deputy head of this committee. I think that this committee's work will definitely result in a greater objectivity of forensic examinations as well as in research activities, especially in those areas where it is possible to create a standard. If there are no questions to Natalia, because I believe this is more of an informational input, I would like to give the floor now to Alexander Asnis, who is the director of the legal firm. I would like to ask him to give his personal view on what forensic examination gives to lawyers, because before this meeting, lawyers were only present as participants, never speakers. But there are always a lot of questions, and there are a lot of issues that we want to discuss. There are a lot of aspects that need to be covered, and I think it was only proper to invite one of the lawyers as a speaker. We spoke to the lawyer community. We asked them to find some time to come here and provide us with the opinion of the lawyer community. So please, Alexander, the challenges and objectivity. Thank you very much, Svetlana. Thank you for providing me this opportunity to speak at this roundtable. I can see a lot of people from the lawyer community, as you called it, and I can see that there's a lot of interest on the part of lawyers to this issue. And as I present my case, I think I will not find that all of the experts and all the colleagues agree with me, because surely lawyers have their own views and positions. Yesterday we had a meeting with Henry Resnick, who is very much against linguistic examinations in certain cases, and this is his position, which can be discussed, even though he is very well respected in the community. I would like to present my own views. I also worked in the prosecutor's office before I became the lawyer. Now I've been working as a lawyer for 25 years, and I think this gives me enough evidence and information to be able to give you my view on this. I think the issues of subjectivity and objectivity in the forensic examination have key significance for court practices, and obviously these issues have been intensely studied by experts as well as researchers. As a representative of the lawyer community, I would like to highlight two aspects of this topic which I believe are of greatest relevance. First, the request for forensic examinations that are not part of the list of examinations which are currently being offered by the state forensic institutions. And the second is forensic examinations whereby experts need to determine whether the actions by citizens or officials meet the requirements of various legal acts. The Criminal Code of Russia contains different offenses where experts are required. the so-called types of examinations. And there are a number of types of such examination practices that are supported with methodologies and specific equipment. In some cases, you could refer to publications, established methodologies, high-quality experts that have spent years in forensic examination institutions as well as in universities. However, in many cases, one can see that expertise from specialists in other areas of science, technology, arts and crafts are required. But these experts do not always have the necessary methodological expertise. However, regardless of the side of the process that initiated such expert examination, one cannot leave this expertise aside. However, often the findings of such experts need to be formulated and written down in such a way that they could be used in court. Today we have already touched upon a very important issue, I believe. We believe that it is important to accelerate the adoption of the bill on forensic examination practices in the Russian Federation. It is being currently read in the State Duma, because it is important to unify terminology, to have a single register of forensic experts, and there should be one federal body that would be responsible for the overall situation with the methodological support to forensic activities. And all of these things need to be in the law, and hopefully they will also be reflected in the various legal processes in Russia. There are a number of international conventions on human rights and the conventions that seek to protect the principles that are important for citizens, and everyone can rightly expect that the same expert methodologies and the same expert techniques will be used without any, regardless of which expert is called for when such an examination is required. And so every person should have an opportunity, should be given an opportunity to look into the content, to look into the description of the methods and techniques used in forensic examination. And that means that the legislation in this sphere should ensure relevance and scientific justification for all the techniques that are used in forensic examination. I think it is high time to create a government register of techniques and methodologies in forensic examination, and perhaps create a database of methodological materials. Often we face problems when forensic examinations are required, especially when experts need to analyze and provide assessment of technical elements. For example, traffic rules, construction rules, fire safety rules, geologic survey rules, etc. So whenever investigation is ongoing, there are a number of, in some cases, even in criminal cases, the defense is denied an opportunity to request examinations because an expert in such a field should meets very specific legal norms of technical nature. It is, I believe, that the defense, in order to make sure that the main principles of fair trial are met, should have the right to provide the court with the findings on various issues that are related to technical issues, and especially when the position of defense is very different from the position of the prosecutor. Obviously, the findings of the experts should not contain any conclusions with regard to the qualifications of the case. There shouldn't be any findings with regard to whether or not someone is guilty, and the detailed explanation could be given in the resolution of the Supreme Court of Russia. I believe that such a resolution could be initiated by the Russian Center for Forensic Examination, which acts under the aegis of the Ministry of Justice of Russia. I believe it is important also to set up a center for methodology that would be taking care of such issues. It is also expedient to organize a special department of experts that could provide interagency examinations that might require very narrow technical skills and knowledge. And when such very complicated expert examinations are required, they might require very specific technical knowledge and understanding of how specific industries act. This department could initiate the inquiry and the use of experts that work in different institutions. I believe that the staff experts of this department could also act as organizers for this outsourced examinations, and could provide methodological support to outside experts in terms of writing their conclusions. In conclusion, I would like to say that I was very brief, and I hope that I have saved some time for you. But let me, in the end of my presentation, to give you one practical example from my own experience. You may remember that some time ago, a few years ago, in fact, there was an investigation in the criminal case against the head of the Moscow Metro, Dmitry Gayev. Then, during the preliminary investigation, a patent examination was required. The defense did not agree with some of the conclusions. In fact, the findings of Russian experts on patent science were presented, and we requested a second examination in this area. This examination was requested. It was given to the most famous expert in this area, who was the head of the legal service of Rospatent. This is the service that has the highest citation index in this research area, and based on that examination, the case was closed against Mr. Gayev. But this area is not on the list of examination services that are provided by government institutions. So what I think is that we should probably think about what kind of examinations could include patent research and patent science. What can be used as a title for this kind of examination? Also, we know that there are examinations offered by government institutions in terms of construction norms and construction rules, and that is great progress. It is an important step forward, because this means that a lot of scope of work is made, and there are a lot of cases when examinations are requested in court, and in this particular case a lot of independent or non-government examination organizations provide expertise. It's not only about real estate. It's not only about non-government organizations that provide examinations within the the requirements. But this is not what is called forensic examination. And I know the approach of Ms. Nassisyan. We have discussed this issue on a number of occasions. I know her arguments. She believes that it is possible to get a specific number as a result of this technical examination. But if you look at the assessment that is provided by experts, usually they give you a range. And then based on the range, we can see that the court decisions in civil cases. So the fact that the government experts can apply for examinations to government organizations, and that there's more these findings are more subjective. I think this is something that we lost, and we lost this market. I believe that we have to change that.
Because in one of the cases, as far as I can see, the colleagues from the investigation committee and from one of the state corporations, there was an investigation carried out, and there was a forensic evaluation appointed under the market value of the consultancy services agreement that was concluded. A number of them was concluded by the state corporation. So inside the corporation there were no experts who could have performed this kind of evaluation, and just this assessment was carried out, and just its results will be underlying the action brought before the court. And I think this is a very important direction. As to the forensic art assessment, there were some cases in my own practice. One of them involved a lot of art assessments, and the questions that were put by the experts were twofold: the authenticity of the work of art and just the evaluation of its price. And just this was an integrated, complex assessment involving art historians, and the art historians would be to judge both on the authenticity issue and the price evaluation. It was in the Federal Center, and this assessment was carried out in the framework of the product-related process, and an art historian was involved, and these two questions, the authenticity and the price estimate questions, were answered, and basing on the results of the expertise, the court ruling was made. When I speak about including a department that will bring together experts on methodology and theory of carrying out assessment process, who will manage the activity of the outside external experts, that will be much more efficient than the activity carried out by the private institutions. As to the illegal forest cuts case, there is an assessment carried out upon the request of the Forestry Academy, not by the in-house experts, by the outside specialists from the relevant institutions. So the damage and the amount of the illegal cut. So the damage is not kind of a legal issue. However, this will underline the subsequent filing of just court suit and the ruling. Another issue is being discussed and comes up in the literature. This is the question of just qualification or just proof of guilt, and because opinions are delivered by our experts in the field of the criminal procedure or criminal law, it's not good, but it's a challenge of time. Because time changes, both prosecutors and attorneys involved in the criminal investigations sometimes are lagging behind considerably from their counterparts who deal in civilist field. So when the court or the investigative procedure can engage an expert in the corporate or commercial law to prove the position that they have formed, I think this is a legitimate thing to do, and however many colleagues in the criminal science, in the criminal proceedings do not agree with me, so I just outlined a number of concerns and challenges that I think request just answers and discussions further. Thank you very much, Alexander Yakovlevich. So may I provide a comment in terms of the answer to the problems that you have voiced. These problems are being solved, but not through the establishment of special departments. In terms of the first problem that you mentioned, in terms of the patent-related assessment, we do such assessments. We get a document into the kind of product-related sphere, because this is a patent and product area, and just the patent experts are involved. In the recent years, we trained how many patent experts throughout the whole country? Please remind me. About 50 patent experts who are equipped with the theory of forensic expert, because you can be a very good expert, a specialist, but not a forensic expert, and just they learn to be forensic, combine the specialist expertise and the forensic expertise. And I think that the non-government institutions are completely legitimate and wonderful once they want and seek to learn what they're not very strong at. Just we know the how to investigate this, but we don't know how to present it in terms of the forensic requirements. So they learn it. That was number one issue you raised. As to the forestry and art assessment, we do them, but single things. I'm not speaking about the Russian Federal Center, but we are doing them either in the framework environmental assessments or art assessments, where the product-related dimension is executed by their own experts in terms of the quality. And as to the expert art historian knowledge, we involve them. So last forum hosted an art forensic assessment section that was presided over by Petrovsky, director of the State Hermitage. Both museum people and art historians just wanted to work together with us as well, but a year elapsed, and so far we didn't move forward a lot. So maybe they are thinking about establishing a department of experts who will do assessments. There were a number of meetings, a lot of discussions, which led nowhere. So we decided, starting from this year, started involving art experts, and we'll see how many appointments or requests for such assessment we have, so how we'll develop in this area. So might prompt the Ministry of Culture to formalize this procedure, and probably the Hermitage will also formalize it, building upon our success. So the evaluation, I think the attorneys have to be precise. We did not give up this evaluation, they took it from us. So when the arbitration court issued a ruling that private experts have to be trained, so this evaluation department just took over from us, a part of our job. So they come to us asking how we can proceed with that, and and I recommend them some ways to achieve precise results. Just you're all adults. When we speak about the undesirability of some control or scrutiny, so many years ago, when forensic assessment was initiated in Russia, and it was 103 years ago, there were private experts, but they very soon realized that without a body that will give some expert advice and provide some insulation or immunity, that would be very difficult, if not impossible, to work. There was an institute that created the laboratories and lists of regional centers of assessments, and just they would perform very similar kind of assessment, but they knew that they will be double checked and supervised. So this law brings nothing new, so it's not targeted against depriving the private investors of their workload. What we seek to establish a high quality and bona fide experts in their activities. So the next presentation was prompted by the facts, by the requests for the panelists, and we just would like to give the floor over to our colleague from Bosnia and Herzegovina, just Liliana Trisic, who will speak about very interesting things and how they deal with the subjective and objective assessment.
Dear preceding Madam Smirnova, ladies and gentlemen, allow me first to express my honor and pleasure for my participation this year again in such an important international conference in the field of law, and especially in the professional forensic science session. I would like once again to congratulate Madam Smirnova for the award given by Russian Prime Minister. I know it is well merited. Now, allow me to say a few words about my topic. Forensic science has made revolutionary change in detection and identification of crime perpetrates, shaping the world of justice, enriching crime investigation, as well as contributing to modern technology development. Forensic disciplines like DNA and fingerprints analysis and identification, classic examination disciplines such as documents analysis, chemical forensic, biological and ballistic examination, as well as modern trend of digital forensic development combating cybercrime contribute significantly and immensely to the criminal justice system. science, the forensic analysis, evidence are used both in crime investigation and in almost all criminal proceedings. Comparison the traces and evidence collected in the crime scene with those kept in DNA database and fingerprint database often results in resolving crimes that could not have been resolved otherwise. Moreover, with these abilities, law enforcement agencies are more and more successful in fight cross-border organized crime and terrorism, since the exchange of information on collected samples and database information exchange in standardization form is a precondition for the efficient international cooperation in criminal cases. A rapid development of forensic science and technologies, including application of IT system and databases, has to be continuously followed up by updating national legislation to enable the police and judicial authorities to fully utilize these instruments. Police work based on crime and intelligence exchange will continue to lean more and more on forensic analysis information to focus the investigation flow and to employ the limited police resources the most required, as well as to enhance effectiveness of the prosecutor's office, which again improves trust of the public in the law enforcement and guarantee that crimes does not pay off. Joint activities of forensic experts, investigative police bodies and the social community represent a solid base for the future of law enforcement all around the world. Considering the growing trend of forensic signification in terms of law enforcement work, EU has set and recommended standards which should be adopted by a member state or a state in process of association through several programs, decisions, directives and resolution, among which the following are most important. Stockholm Programme, which includes the Council of Europe requirement to agree on common quality standards within the forensic field, also to develop best practices in conducting crime scene investigations, as well as to improve capacity in financial investigation, combining all available instruments under the fiscal, civil and the criminal code. Forensic financial analysis is to be developed according to utilization on common recursive principle, particularly in the field of training education. Action plan for implementation of the Stockholm Programme. The Commission is requested to assess Council Framework Decision 2009/205 GHRA on accreditation of forensic service providers carrying out laboratory activities and possibility of development of common quality standards within the forensic field. Should fall up in 2015, and it's an obligation set for all the EU countries until 2018. Framework Decision 2009/205 JHA reaffirming the need to ensure the effective and appropriate exchange of information regarding the scientific evidence and the increased use of forensic data from one member state in the judicial process and another, foreseeing the need to define commonly accepted minimum forensic science standards. Prüm Agreement, part of the Article 24, introduced procedures for promoting a quick, efficient and cost-effective ways of data exchange, which is of fundamental importance for the efficient international police cooperation. EU member states guarantee each other access rights to automated database on the DNA, fingerprints and vehicle registration. Council Framework Decision 2006/260 JHA on simplifying the exchange of information and intelligence between law enforcement authorities of the member states of the European Union, so-called Swedish Initiative. Besides, a European network of forensic science institutes, ENSI, has developed into a central platform in forensic science field and issued a set of particular development recommendations that should be applied by their members. The final goal, the goal of the legal reforms in Bosnia and Herzegovina to fully harmonize national criminal justice legislation with the international law with regard to the human rights, as well with new modern initiatives in criminal legislation that have already been in use in the countries of EU. Final and full harmonization of the criminal legislation with the international criminal law is an obligation stipulated not only by international documents but for the Constitution of Bosnia and Herzegovina too. Bosnia and Herzegovina is one of very few European countries which have recent both its own new system procedural laws where the criminal proceeding is regulated in a rather different manner. According to those procedural laws, model of criminal process in Bosnia and Herzegovina is combined accusatory inquisitorial with some characteristics which make it a special model of combined type of criminal process. It is important to underline the criminal code of Bosnia and Herzegovina set in this way clearly position Agency for Forensic and Expert Examination as an administrative organization within the Ministry of Security of Bosnia and Herzegovina with operational independency. As known, Bosnia and Herzegovina has taken a commitment to establish a functional police structure of BNH through the visa liberalization roadmap and EU stabilization and action agreement by adopting appropriate regulations which would adequately address the issue of forensic and expertise as a support to police body and other competent law enforcement authorities at the BNH level. The Agency for Forensic and Expert Examination was established pursuant to the law on the Directorate for Coordination of Police Body and the Agency for Police Structure Support in Bosnia and Herzegovina as the result of the second phase of the police reform in Bosnia and Herzegovina and become operational in February 2009. The Article 14 of the mentioned law clearly defines competencies of the agency. Ballistic and firearms analysis, chemical and toxicological analysis, fingerprints analysis, graphology, graphoscopy analysis, biological analysis, biochemical analysis, DNA analysis, specialized training, keeping records, statistics and databases, fire and explosion expertise, provision of professional assistance to other bodies comprised in this law, standardization of the field work and other work provided by the law and other regulations and keeping records according to its competence pursuant to the regulation in force. The establishment and work of the agency in the security sector outside police structures has created a realistic precondition for objective, professional and impartial expertise in complex cases of organized crime. Upon the others of the competent prosecutor's office and courts in Bosnia and Herzegovina, which is in line with the standards defined in the Convention for the Protection of Human Rights and Freedoms. The process of police reform contained the method of reform and modernization. Accordingly, creating this agency was in compliance with European regulations. In this case, the organizational separation from criminal police forensics departments and the uniformed police competencies, and its response obedience of international standards and protects the agency for being buyers in its analysis and presentation of evidence. It was obvious that the police work had to be aligned with international standards and that an independent forensic structure was according to European requirement, and therefore establishing this agency with its competence defined by the law, armed to assist and contribute to the professional, impartial and efficient manner of conducting the investigation and court procedures. Bearing all this in mind, as well as the major and fundamental objective of the agency is to contribute to the rule of law and improve conditions in the area of safety, the agency shall permanently, in cooperation with the competent prosecutors' offices, courts and police agency, analyze crime trends and the most common types of criminal offenses and use the results of analysis as one of the directing parameters towards modification and development of its capacity. Ensuring protection of the human rights and freedoms requires the legislator to monitor dynamic development in the field of protection of fundamental rights and freedoms and construct the powers of the criminal proceeding bodies in particular situation where, due to request for efficient processing, the interests of the country are above the interest of an individual, i.e. when it is necessary to include arbitrancies, contrarians and violation of basic human rights and freedoms. Without going into a theoretical discussion of facts, finding manners.
Да, ответьте на вопрос. Есть объективность?
Please ask me, answer a question. Is there objectivity in forensics in Bosnia and Herzegovina? Because you present an ideal Plato's picture, an ideal expert, an ideal forensics, and I will repeat myself. From your excellent presentation, Channel 6. From your excellent presentation, it follows that in Bosnia and Herzegovina, the expertise, this forensic examination, and the activity of courts is ideal. My agency, which I represent here, is new agency, new part of security and judge system, and we plan to do good, but really situation is something else. But now we have good results.
Из выступления все отлично.
Well, judging by your presentation, everything is just fine.
An expert is a specific subject of the process, expected to provide impartial information, facts and opinion on specialized issues that a prosecutor or a judge could not provide, even if they had specific knowledge at highest level. An expert, even though replaceable as an individual, is not replaceable as a subject on the court's proceeding, criminal and civil, and his function should not be mixed with the functions of other subjects. Position of the agency as an independent administrative organization is clearly defined also by the provision of Criminal Procedure Code by Articles 112 to 115, analysis of DNA, from which it follows that the protection of data obtained by DNA analysis are conducted under the provisions of a special law, that all the analyses are kept in the special registry, as well as DNA analyses might be conducted exclusively by a specialized institution for this type of expertise. A recommendation of the application of DNA analyses in the criminal justice system, number 92, one of the Committee of Ministers of the Council of Europe member states, was accepted at 417th session of 10th February 1992. Recommendation stipulates that member states will strive for standardization of DNA analyses at the national and international level through mutual cooperation, and that the conclusions of the international exchange of DNA analyses carried out in such a way that it will be possible only between countries that accept and generate condition by the recommendation, in particular in accordance with the relevant rules of international exchange of information related to criminal cases, and in accordance with Article 12 of the Convention of Data Protection. Also in 2008, two Prüm decisions were brought on cooperation in criminal matters regarding the exchange of data on fingerprints and DNA. Countries that are in the process of their accession must be brought to accord with the legislation of the Prüm decision, which provide that laboratories performing DNA testing, as well as staff working in them, must meet international standards adopted by professional organizations in Europe, as well as to have international accreditation, laboratory accreditation in accordance with ISO IEC 17025. The basic intention is to form a database of DNA profiles obtained by analyzing biological traces in Central Forensic DNA Laboratory with legal entity status and operating in accordance with the rules on public services and offers, and regulate it by law. Practically, it would be controlled by the state, and the law would stipulate adequate procedures for the protection of collected data. Constant monitoring of new scientific developments in the field of forensic examination and expertise, their application in everyday work through technical equipping with permanent professional planning and training of personnel, the application of standards and accreditation of forensic laboratories can provide full probative value on objectivity of the forensic examination results in court proceedings, and can be the response to new forms of crime. Thank you for your attention.
Спасибо большое. Спасибо за очень...
Thank you very much, Liliana, for a very interesting presentation. Liliana is the director of the Agency for Forensic Examination, and because this is a new structure, she wanted to share with us how it all happens there. So while they are building Plato's republic in Europe, an ideal republic, we will have to come back to our somewhat different phenomena when forensic examination is done by an unfair participant of the court proceedings. And I would like Sergei Chuprigin, a partner in a law firm Ivanian and Partners, to share his opinion about this. Thank you very much. Good afternoon, esteemed participants, ladies and gentlemen. I would ask the three remaining speakers to be more concise, because certainly everyone wants to speak, but we don't have much time. Allow me to welcome all the participants of the forum, to thank you, Svetlana, for a possibility to make a presentation at this round table, and to identify problems that we lawyers sometimes meet in practice. The subject of this round table proposes the discussion of such ideal models of how all that should function. Yes. But any ideal model is only viable when there are challenges in practical life and whenever there are needs in practical life. I would start my presentation by quotation by an ancient Greek philosopher to bridge the gap between the ideal and the practical. And he said that theory without practice and practice without theory are nothing. And this demonstrates the major law which is applicable not only to forensics but to any sphere of activity. Practice and theory are mutually complementary and form a symbiosis which allows to develop an area of activity or science. Coming back to the practical issues, I would like to speak about certain aspects of forensic examination when it falls into the hands of the so-called unfair participants of court proceedings. And in my presentation, I tried, based on my many years of experience, to raise the problems that you have to come across in everyday life. The purpose for the forensic examination is to explain to the court or to the judge something that demands special knowledge. In some sense, that makes the judge a hostage of the expert's opinion, and quite often forensic examination has a great importance as evidence. So the judge steps back, so to say. He just tries the expert opinion, and in that sense the issue of expert qualification is of great importance. And if such examination is done by an unfair or unqualified expert, the judgment sometimes does not meet the requirements of the court. Well, first, the terminology for our discussion. And there are different approaches to the right violation, but this is, in our opinion, such a when this right is realized to inflict harm on the other party in the court proceedings. So the next issues that I will describe have been the result of my practical activity. When do we come across unfair behavior which act in conjunction with so-called puppet experts. I apologize for this term, but despite the law stating that the expert must be independent and impartial, unfortunately, the real life proves that experts are sometimes work together with the parties to the process. Such cases are very difficult to identify, and the mechanisms of doubting the impartiality of an expert, well, every practicing lawyer will support me when I say that, unfortunately, these regulations do not always work, because it's very difficult to explain to the court why you doubt the impartiality of the expert. You have to be guided by your intuition when defining whether the expert is partial or not. Quite often, a party asks for a forensic examination just to prolong the court proceedings, especially when initially the expert failed to answer all the questions, when additional examination is needed, and then the court becomes a hostage of the expert opinion and wastes a lot of precious time, while the wrongdoer remains unpunished. And the second case of such unfair behavior, and it was already briefly mentioned today, is the fact that such puppet experts, and I once again apologize to my colleagues from the independent expert community. I know non-state experts who are real professionals. I'm not talking about them. I'm talking about the problems that unfortunately exist in our practice. Like I said, the second kind of such behavior that results in the violation of rights of the parties in the process is that the puppet experts quite often make their conclusions in the interest of the party that they serve, thus corrupting the truth that is necessary for the proceeding. And the third type, of a very specific type of such a violation, which I faced recently in the course of a corporate dispute, was that the expert was used as a tool for obtaining information from the other party in the dispute. That was an interesting situation that I faced. The matter is that the expert, and every practicing lawyer knows that when a judge appoints an expert, he requests a expert organization, and they provide the judge with a list of information needed to answer the questions. We came across a paradoxical situation. The judge asked 4 or 5 expert organizations. 4 of them presented more or less identical lists of information, while one expert organization sent in the list of documents and information which was 2 times longer than those of other organizations. Probably that was an evidence of high professional qualities of that expert, who tried to really look deeper into the situation, but our intuition told us that that was probably not the case, because other experts decided that the list of such documents must be limited. And all those issues provide for a possibility of such violation of rights, and it was already mentioned by other participants, and this is probably due to the fact that there are no common standards and methodologies that would be mandatory for independent or non-state experts. countering such violations could take the form of creating a kind of a filter that would not allow the experts who do not have the necessary competences and skills to take part in the court proceedings, and the law on the forensic examination, which was mentioned, solves this problem because it introduces certification of experts. But this certification is inadequate because a non-state expert organization may be used or employed in court proceedings if one of the experts is certified. But probably this will be amended, and the next area which could be suggested and supported in order to counter such unfair practices would be to unify all those methodologies. So there must be a single standard for state and non-state experts. Coming back to the problems that are already mentioned, I believe that this could be used to very efficiently oppose such unfair experts who are trying to get hold of information they shouldn't have. It's very easy to superimpose such a template on the behavior of such an expert and to identify such unfair practices and try to counter the appointment of such an experts. Another way of countering such instances is increasing the part played by the judge. Svetlana said that once a month judges meet members of the expert community and consult them. So the judge should not be passive. The judge must be more proactive. And despite the fact that the judge may not have special knowledge, they must try to understand the quintessence of what has to be found with the help of the competition in the court, and to reveal the real intentions of the expert who is used for the court, for the forensic examination. And the last thing that has not yet been reflected in the law is probably submitting a draft law for experts' responsibility for disclosing information. We are living in an information society, and any information that has been disclosed and may have been acquired by third party may be capitalized and lead to a conflict of interests. So to minimize those deficiencies, probably the law might establish responsibility of an expert for disclosure of information, and probably this would be another incentive for the unfair experts to think about whether it's worth disclosing information to the parties in the court proceedings. So thus I tried to reflect on the circumstances that show the real problems that experts and judges have to face on a day-to-day basis, and I hope that my proposals will be reflected in the draft law, which has been in the parliament for 2 years, and probably it's worthwhile trying more actively to pass that law in order to structure our court proceedings and to move towards that ideal future which was described in the beginning of my presentation.
Thank you very much for this brilliant presentation. I believe that we do move forward, but it seems that those who do not need this ideal world are moving forward as well in their own direction. Well, let's do something about it. Let's suggest something about it. We have 2 presentations left, dear colleagues. I'd like to give the floor now to the director of the Forensic Center of Armenia, Artashes Javadian, and I think he will talk about a very important topic. So what is it that is of so much importance to all of our colleagues? We're going to talk about the databases that our colleagues from Europe mentioned. Also Anatoly mentioned it in his presentation. So please, Mr. Javadian, tell us what has been done in your republic. I know that in 2012 you held a conference that brought together European and US colleagues. There were a lot of colleagues from Russia, and we heard about the volume of work, the scope of work that Armenia managed to complete, but nobody wants to share the databases. So please, the floor is yours. Thank you for giving me the floor. I know that everybody is a bit tired because we've had a lot of presentations, and I'll try to be brief, well, at least briefer than I planned originally. Databases as the instrument of objectivization of the forensic examination process. Let me explain why we believe that databases are important. Today, when forensic science and criminal science has been improving, but at the same time the methods and techniques used by criminals are advanced as well, and often the criminals are ahead of investigators, especially in the cyberspace, in illicit drug trafficking, etc. It is important for us, for the expert community, to join our forces and exchange information and advanced technologies. And of course, obviously, one of the tools to transfer and exchange relevant information about crimes is the databases. I tried to mention the most important databases that are most relevant to us. I have to say that we do not have any single definition about databases, but only after you have studied a lot of different publications, we can say that the collections, the register that we have, they can be used as databases, especially if they are digitalized, if they are scanned. Also, there are new databases that have been created in the past few years. I wanted to give you a number of examples here so that you had it clear. It was clear for you what we're talking about. For example, firearms traces, ammunition traces. Obviously, a lot of Ministry of Interior institutions care about this. We know that there have been some advances. They now have digitalized databases. It is possible to search these spaces. There are DNA databases, databases of micro objects such as microfibers, paint and lacquer coating. Then there may be some databases for psychotropic substances. There could be databases for tire treads, falsified and fraudulent coins and bills, DNA system, etc., etc. This is a very abbreviated list, and I only mentioned the most widely used databases. But these databases are well structured. It's not just a mass of data. And therefore, in some publications, we can read that every natural collection should be treated as a database. And as I studied what database can be used, what things can be called databases, then I can say that there are well-known databases such as passports of the world, firearms of the world, the theoretical parts, but also empirical collections that can be accumulated by specific institutions. And these collections are grown and accumulated by institutions based on their everyday activities. Obviously, every database requires its own technology, especially when it comes to equipment. We have databases on chemical compounds, and these databases are important in order to be able to identify substances. There are a number of very successful databases that are used in everyday practice of our colleagues abroad. The automatic fingerprint identification system, the so-called IFIS. Obviously, the next one, which is also very well known, it's the IBIS system. If you have IBIS, you can easily talk in the same language with US and European colleagues. This is the integrated ballistic identification system. Then there's a DNA system, which is called CODIS, Combined DNA Index System. And there's a number of other databases which may be present in some countries and may be lacking in other countries. Ignitable liquids reference collection, the so-called ILRC. Forensic information system for handwriting, the so-called FISH. It's very widely used in the US. GLASS evidence reference database, that's also an American database. International Ink Library, it's an international collection of ink samples in the States. Again, National Automotive Paint File in the States, a Paint Data Query, etc., PDQ. So these are some of the successful databases. Now, with regard to databases, I would like to focus here mostly on the fact that there are a number of databases that are used by the European Union, and we know that the European Council made a decision which is relevant to all of us. It is a decision on the vision to 2020, on the creation of a single space in this area. And there are a number of activities that were detailed out here. This decision is a directive. This is a decision that is compulsory for the European countries that are part of the European Union, but this can come as a recommendation for us. The identification of possible techniques and methods that are used in order to expand the databases. We have our own databases, and our center has been working on this database for a long time. For example, the databases of munitions and data from ballistic examinations. We have a database, I think that might be of interest to you, the so-called contact grams. We accumulate this, and we started 13, and now we continued into 14 and 15. The idea is that some of the experimental developments make it possible, or at least we give us an opportunity to use such contact grams when we have comprehensive chemical and ballistic examinations. In some cases, we can determine the direction of a shot. We can determine the order in which the shots were made. So this is a very specific but very useful database. In my presentation, however, I'd like to focus mostly not just on the fact that there are databases available. I'd like to mention how these databases can be used when we have multimodal examinations, when there's a multifactorial analysis. In order to be efficient and efficiently apply these databases, it's important to unify and have a uniform search. And obviously there should be an exchange between the users. Optimization of the legal regulations surrounding the database should be solved both at the national and supranational levels, within the associations, unions, and we can give you an example of the European Union. There are directives by the European Union on DNA databases, and Liliana earlier mentioned this database in her presentation. There is a European collection of GLASS and paints, and they are stored in relevant institutions. For example, in Wiesbaden, the paint collection is stored. This is a database on lacquer and paint information, and the member states of the European Union can use this database. There's also Europol and other organizations that assist in the accumulation of this database. Experience of Europol and Interpol are very useful for this database. I'd also like to say a few words about the procedures for information exchange. So how does that exchange happen? We have a number of successful cases. I have a table here, a matrix showing you different ways when the exchange is ensured by indirect keying in of the new data. There's also a human aspect when people communicate and get information from each other, but at the same time there are cases when the governments ensure the full control over their databases, but they make it possible for other countries to use their databases for search. And there's also a case when governments are in control of their databases, but there is a central index that can be used by several countries. And further on, it is possible to receive specific information on a lower level. And then, of course, there is another way to create a central database for a union or an association of countries, such as the European Union databases. Well, obviously, there's personal information exchange. There's exchange of practices, but there's also classified information, dual-use equipment or materials, military equipment and materials. Let me give you two big examples of comprehensive analysis that we conducted and the use of databases. For example, whenever we need to use the database to refer to lacquers and paints, but also sometimes when we need to refer to databases on fingerprints. For example, there are culture and there are examinations with reference to cultural and objects of arts, and often it is important to add examination of lacquer and paints, etc. So these databases can be used in different areas. I would like to emphasize the need to exchange information and practices between countries. It would be difficult to work only within the national framework. For example, when we do examination of Russian objects of art, it is useful to use databases that would contain information about Russian art. And the same is true about Armenian authors and painters. So whenever Russian experts need to have an examination of an Armenian piece of art, they need Armenian databases. If you have an artist who needs to be authenticated by an expert, the experts can refer to various databases, and every time there is examination, something just switched over and switched off, and I need assistance here.
Well, we show how we extended and expanded our material, lacquer and paint basis in 2008. In the framework of the cooperation agreement, our collaborators had an internship and exchange program with the State Hermitage as an example of the information data basis exchange. So just things like style, literature and others as an example. So Another example is using databases exchange. So the first example, please. A painting by Saryan dated by 1925. We carried out the examination of the canvas fibers and identified that such canvas could have been only produced in this year. So the handwriting assessment was based upon the database of the artist's signature, and we succeeded in proving that that was a fake. Another example is a painting by outstanding Russian artist Vereysky. So we use the integrated database provided by the Hermitage, and we also found that important things due to the access to these databases. Another very important example is the database of fake artworks. And we also just hooked up to Interpol basis, so I'll also ask for another 5 minutes so that we could... But our microphones will be just turned off because we need to wrap up very quickly. So then I'll show another 2 slides and we'll finish off. We use the sweat and grease deposits combined with fingerprint analysis this is just search work carried out to identify certain diseases, because if a person is has a certain disease, he kind of extracts certain substances. So acetone was detected, and it was quite clearly seen that there was some kind of metabolic defect. And another finding was that there's a non-equality of the lacquer painting. Was a good testimony to identify that this person was engaged in this kind of work. So this combined investigation was very important. Chemical imaging, the method of the London Imperial College. This is a joint work of ours. Unfortunately, I have no time to give you more details. To conclude, I would like to present 2 very new databases, development of biometric crypto system based on the vein pattern on the palms, together with the fingerprint investigation. It gives a higher level of precision, and just another biometrical database project that we are doing in conjunction with the Computer Institute of Armenia. To sum up, I would like to say that it is very important to achieve the mutually agreed position of the international forensic community using databases in 2 areas: having single uniform approaches to their establishment, operation, and prompt access to the authorized users. And the second is legal regulation in exchange of the probative evidence in the court proceedings. Thank you. Thank you, Mr. Javanyan, for your wonderful presentation. Because experts just have little time to talk amongst themselves in daily routine, so we perceive this database as a small step towards achieving a more objective and precise results of the investigation. So what are we to do with our very last presentation? Do we still have time? Yes, we have time to listen to Isidor Shamilevich. But the girls are saying that no, we are not going to do it in 3 minutes. So, Artashes Sergeyevich, I can't stop you or somehow limit you in time, although we fit the 15-minute time frame. The discussion was very lively and important. In terms of the private and state forensic experts, so maybe you will share your scientific expertise. He's a professor, head of the Kazakhstan Forensic Center. which we can really learn from, which is our constant partners, both the experts and the leadership of the Institute. Please, could you offer your opinion as to what it is that we achieve through this roundtable discussion today? I would very much like to congratulate you first and foremost. This is a real achievement of the forensic expert community of the Russian Federation and ours as well, because under your guidance we worked very effectively, and we appreciate your assistance in terms of the methodology and practical devices. And within such a limited time frame, I would like to focus on two important aspects. We are experiencing a reorganization of our activities. In 1997, the head of the state was transferred to the Ministry of Justice. So on the 31st of December, a new state program was adopted to modernize the law enforcement system, and as an individual area was development of forensic evaluation. These documents provide for the further centralization of forensic evaluation, and the implementation of these important documents foresees that from the 1st of January, forensic evaluation is under the ministry, was under the Ministry of Justice, and from this then the psychiatric evaluation and others. So accordingly, we need to amend and change our legislative framework. There are 4 codes that were entered and produced. So the criminal code, the administrative offense code, and criminal procedure code, and the penal code. As to the first two, they are regulated by the appointment of the forensic evaluation. I headed the task force to develop the administrative offense code, and we succeeded in including all these issues there. As to the criminal procedure code, there are some challenges which I would like to briefly share with you. Or if it's not of major focus, let's focus on our achievements and progress that we made. So you spoke a lot about the need to have common uniform methods. In Kazakhstan, the state experts and the private experts are both governed by just common methods that are part of the Federal Register. So we also have a draft law which we forwarded to Majlis, and there is a special section there that looks upon the activity of private experts, and legislation stipulates the creation of the just a chamber of the private forensic experts. It's a very good idea. So when we talked about the private experts' activity, they should whether they should go through the accreditation and just to which extent they can have the autonomy. But we shouldn't discard the fact that each expert evaluation is based on specific fates of people in Russian Federation and in Kazakhstan and many quite progressive constitution countries. The decisions are based on the basic human rights implementation, and we're also based on that. The importance of training, without which there is no progress and way forward. We cooperate with many universities of Kazakhstan who specialize in technical and other evaluations, and also it is important to mention the evaluation activities. There were problems with evaluating land plots, so if evaluators give one sum And if we take it as 100%, and the second evaluation in 98 cases, the first opinion was not confirmed. So they're working under the Ministry of Justice, and there was a resolution by the minister. So the two we sat down to develop a common methodology, which was approved by the ministerial resolution. It was made into a legal act, and today the discrepancy is minimal. Thank you. Thank you very much. Dear colleagues, guests and participants, we are wrapping up our roundtable discussion. I'd like to thank all the panelists for great, very in-depth and detailed presentation. You made a mammoth effort to prepare your presentations, not just to speak about something, but you sounded very professional. And I would like to cite Novella Matveyeva. Everything has been said in there. There is nothing that has been said. However, there is a kind of a light of the non-said that guides our lives. So I would like to wish you this light cast upon the problems that we all will resolve in the mutual effort. Thank you. Dear Нас отключили.
В прошлом году она касалась.
There was a reward that was what was given, and we were also modeling on the Eurasian Economic Union tradition to have nominations, and we want to follow it and award a unique medal to celebrate the contributions of the unique experts. Together with the Ministry of Justice, we would like to award you with this medal for the contribution to the forensics, and we would like to award these medals to two outstanding practitioners. First, Mr. Jan de Kinder, the chairman of ANSI. This is a medal that has a symbol of the ANSI, and just then there is an inscription for the great contribution to forensic science. Unfortunately, the word development could not be fit within the size of the medal. And also we would like to congratulate the moderator of today's round table, Professor Svetlana Smirnova. She just, for an award she received a couple of years ago, and with our medal, this is a medal to award your well-earned title from the Eurasian and other professional communities of forensics. We would like to praise you for your contribution to the forensic science. Thank you very much. Good health and every success. So medal number 1. Thank you very much.